Welcome to From the Field, an opportunity for us to get in touch with experts in their field to help us answer some of the most challenging questions in the creative industries. Today, we're going to be talking about who owns your creative work, specifically intellectual property and copyright.
Yes, and we have a tremendous guest to speak about this. It's Louise Torr from Harper McLeod, a very reputable law firm here in Glasgow. And it is a challenging one out there for people who are creatives, work with creatives, hire creatives, and also commission creative work. Stick around to the end because we're going to run through some scenarios, whether you're a freelancer, sole trader, you're an employee, or perhaps you're a client or commissioner. And those scenarios will ideally help you work out who owns your creative work, or indeed the creative work that you've paid to commission. So without further ado, Louise, thank you so much for joining us. Let's hit you up with a real hard question to begin with. Please introduce yourself and what you do.
My name is Louise Torr. I am a lawyer at Harper McLeod Solicitors. I work in the corporate and commercial team, so helping businesses with all aspects of their business, from incorporation, growth, through to exit, and everything that happens in between, which normally involves quite a lot of intellectual property.
So Louise, for those who might not know, what exactly is intellectual property?
So intellectual property is something that's almost inherent in absolutely every business that there is out there now. Like you say, it involves copyright. It's a legal right that arises either by nature of law or by registration, and that can include copyright, trademarks, design rights, patents, and that can be within the UK, and that can also be worldwide. Intellectual property is protected jurisdictionally and in relation to a lot of aspects which we can come on to later, but that's generally what we're talking about when we refer to intellectual property.
Very well explained. So in regards to that, how does one go about protecting your intellectual property then?
In terms of copyright, which I think is probably more applicable to this audience, it's not registrable, as I said earlier, and so it's important for you to understand who owns the copyright, whether there's anything in writing to dictate otherwise. By operation of law, to strip it back to its most basic terms, if you are recording this interview right now, you are the one that's operating the camera, you are the author of the work, and therefore you own the copyright in this work. So it's a literary, musical, dramatic, written, recorded piece of work, then that's copyright, and it generally sits with the author unless there's anything agreed otherwise. That's why it's always important to understand, well, who is actually making the production, who is it that is actually, holding the camera and making the recording, because essentially it is them. When it comes to production work, there can be really complex agreements in place between all the parties so that it's clear who owns it and whether or not it's jointly owned. In some productions you could have producer and director jointly owning some of the production, and so it's just making sure that you're clear where that intellectual property sits and where it should sit. What is the intention to make sure that that actually happens?
Well, if that's the case, how does one protect their creative work and prove ownership of that creative work?
I think it's just making sure that keeping a record of what it was that you created, adding a digital signature to it if that's something that you're able to do, keeping a database of everything that everybody's done. If you've created content that you are putting on your website, for example, you might want to put the little C in a circle copyright sign 2021. Legally it doesn't necessarily mean anything, but it's still kind of making that statement to others that is copyright that is owned by whoever it is that's operating the website. It's more taking practical steps to make sure that you've made your claim to it. The next strand up from that is when you are maybe creating something for someone else, making sure that you are clear with that other party. Well, who is to own this intellectual property? And the classic example is, should it be me until you pay me in full for the work that I've carried out? At which point it's automatically assigned over to whoever it is that's asking you to carry out the work. And the employee-employer relationship, there wouldn't necessarily need to be that next stage of assigning it over. It should, if you've got the right employment contract in place, it should happen automatically. But also understanding if you are being commissioned by somebody else, or if you're commissioning somebody else, just being clear as to where should that intellectual property be. Are you just giving us a license to use what it is that you've created, or are you actually giving us full ownership of it? And sometimes a license is perfectly acceptable for parties, so you might be able to retain the ownership but actually just license the content to someone else, and that can be exclusive, and that you are not going to give that content to anybody else for a certain period of time. It might be exclusive in a particular area. For example, it could just be in Europe, whereas you're allowed to give it to somebody else and license it to someone else in the States. There are different models that you can use, and it really depends on what the person that you have been commissioned by is planning to do with it. From a selling or investment perspective for a business, investors or purchasers would always want to try and make sure that the intellectual property is owned by the entity that they are either putting their money into or acquiring. But in some businesses, particularly the type of businesses that all you guys are working in, there might be nuances around that mean that it's not typical for that to happen that way, and so a license is perfectly sufficient. But again, there is a concept of an implied license that does arise, and which is a recognised type of agreement, I guess, albeit in the absence of writing. That would be something that a court would have to assess as to whether or not that license has actually been implied, and you'd have to take evidence around all of that as to, well, what did the parties agree, and what did they agree in writing, if there were any emails, because there isn't anything in writing to dictate what the license should be. So that is a possibility. That's your fallback position, but there's absolutely no guarantee that you would be successful in there being an implied license. So that is, I guess, your fallback position, but I wouldn't rely on that. I would get something in writing if you can.
So in regards to getting it in writing then, how much does need to be recorded in writing? Because I think what we can take home from that is that there needs to be agreement and understanding, and ideally something in writing. How simple can it be?
The point to make is that these agreements don't necessarily need to involve 50 pages of text. That you can have things that are quite simple, and in some scenarios, whoever you're contracting with you might have a consultancy agreement that you would just be able to roll out every time you subcontract the work that you're carrying out for another party, in which case it would just clearly state that anything that you create in relation to the project, and you would say what the project was, then that intellectual property either, it comes up to you, and that allows you to then transfer it up to whoever it is that you've been commissioned by, if that's the relationship.
So I think most of us know the answer to this question, but it's a common question regardless. Can you use someone else's work without their permission?
The short answer to that is no. I mean, practically you can, but legally, no, you can. And if somebody discovered that you were, then they would be able to take action against you. Whether you knew it or not, they would have a right of action against you. So that's, again, going back to the point, making sure that what you're using, you have the ability to do so without infringing anybody else's intellectual property.
So if you are commissioned to carry out some work for a client and you are the creator and therefore the owner, how does that transfer of ownership happen, and what rights do you have to, say, use that to promote your own work? Whether you want to or not, do you have the right to do so?
If I'm putting a contract together for, say, a website developer, for example, we would have terms that say, upon creation of your website and payment in full by you, we are assigning all intellectual property in the website to you, whatever the company is. What they often ask me to do is to put a clause in there to say that, whilst you own it all, you're granting us a royalty-free, non-exclusive, worldwide license to use what we've created in terms of our marketing materials, in terms of our own internal business development, just so that it allows the creator to then say, well, actually, like 10 years ago, I actually created TikTok's website, and so, that's kudos to me as a creator. So sometimes you might want to retain a little bit of it, but usually, it's a commercial discussion as to whether it's a license or an assignation, and whether or not it's exclusive and you can use it to give to anybody else. They're all commercial points, but that can all be set out in the agreement, and it's not, I wouldn't be shy in asking if you can still retain a license to at least use it for your own marketing purposes, that you did certain pieces of work for certain individuals or businesses.
And how is technology changing the way we prove ownership of our creative works?
Yeah, I guess the legal industry's trying to keep up with all the developments that go on and blockchain and what comes out of blockchain and how that is organised and how that is legally protected and how things are verified. I think we're getting there, but there's still probably a long way to go. With NFTs, for example, I can see the benefit of having them and the ability to prove ownership. Well, not even ownership, as we sort of had an offline chat before we came on here. As I understand it, in a lot of instances, the copyright doesn't actually transfer with the NFT. The copyright is actually still retained by the original author. The owner of the NFT then has the ability to use the virtual work in certain ways. Now that might not even be commercially. That some of them might even be so far as to restrict them to just for personal use. Again, I think maybe the commercial benefit comes from being able to resell, as you said yourself, and so I can see that developing certainly, and I think it sounds as though they are working on it to make sure that the verification process is bulletproof, because I think from what I had read, one of the issues was maybe that the information could fraudulently be put on the database to begin with, and then there's no way to verify that, and then it just continually will follow. All of the changes will just automatically continue and follow on from that, even though at the top level it was the wrong information that was put into it. So I still think from and I will not profess to be an expert on this, but from what I understand, I think there's still a bit of making sure that the verification process is absolutely watertight. And then in relation to smart contracts, again, we kind of briefly discussed this earlier, but there is still the uncertainty around whether or not legally a contract can be concluded in the way that smart contracts operate. Even now in 2021, particularly in Scotland and in the UK, we've had to move much more towards digital signatures and digital electronic signatures, using DocuSign, for example, and getting comfortable on whether or not from a legal perspective that actually works. And I think they are getting there, and I can see us moving in that direction. But I think at this point in time, certainly it would certainly help if there was ever a debate as to whether who owned the intellectual property. I think it would certainly help, but I do think that maybe there's still enough uncertainty around there to not convince a court that is definitely a bulletproof way to prove it. But I do think it would help. It would be taken as a whole in terms of what other evidence was presented. So I do think that it will help in terms of proving ownership.
Louise, thank you so much. Really interesting. A lot to wrap our heads around. I can see why you do the job that you do. So let me hit you up with some scenarios. I'll take the first one. And we're talking a freelancer or a sole trader. So someone who is self-employed. They're hired by a limited company who is their client to create a 3-minute video. Now, the freelancer themselves hires a second freelancer as a second camera operator just for a day, and they're to capture some additional footage. A copy of that footage is then provided to the original freelancer that got the job with the client, and that's to be used in the finished video. There's no contracts in place between any of these parties. It's just simple invoices are used, email communications, and probably some phone conversations. Everyone gets paid, all goes swimmingly, the video's delivered to the client, and they start using it. The question we have is, who owns the creative work?
So in that scenario, there's a couple of things. The original freelancer, presuming that they are doing some of the filming themselves, they will own the part that they are filming themselves. So when they're filming it, they own the right to that content. When they subcontract to someone else and that operator videos a certain piece of content, they own that piece of content. When that is all stitched together, then there is an argument as to whether or not that becomes a new piece of work. But I think in that scenario, you may end up in a situation where there's an argument that's actually joint ownership of the intellectual property in that particular production. And so the ultimate commissioner who commissioned you to do it actually doesn't own anything at all. Now, I did briefly mention the implied licence, and there could be an argument from the Commissioner that an implied licence does occur in this scenario, but this is one of those situations where it becomes quite messy, because actually, if you're just stitching together the two pieces of work, does it become a new works, or are you using two separate pieces of work, and so there's a joint ownership? Now, if the evidence was there to suggest that the piecing it all together, if you were doing it, maybe if you were doing some editing and things like that to the quite large scale editing to, and it became a new video, then you may be able to make the argument that you, as the initial freelancer, owns it all. But I think you're probably going to be quite hard pushed to make that argument, and that your camera operator could say, well, actually no, you're using part of my content, I didn't grant you a license, I didn't transfer it to you, so actually I want part of whatever you're commercially benefiting from that. So in that scenario, the best thing to do would to be have a contract between Commissioner and freelancer that says that anything that you're creating, once I pay you, comes up to us. And then, do they allow you to subcontract? Just make sure you check that point. If there is something in writing, can you subcontract? Usually what you'll find is if you can subcontract, they would be wanting to see evidence that you also had an agreement in place with a subcontractor to make sure that what they did produce flows up to you and ultimately up to the Commissioner. And that would be the way to deal with that from a legal perspective. But obviously in this scenario, it's a mess because there's nothing, and they're in reality, a lot of these things are just agreed amongst the parties and they sort it out themselves. But if somebody was to argue about it, your content was used in a massive multi-million-pound project and you were getting paid quite a lot from it, then that's when people start to change their mind about how accommodating they want to be. So yeah, always worth just setting it out in writing and hopefully avoiding any argument whatsoever.
So in terms of setting that out in writing, would having that invoice stating specifically the deliverable and those email conversations, would that definitely help as evidence, given there's no contracts in determining that copyright, given what we've discussed earlier?
Yeah, that's all you could use in that scenario, and it would depend on what the agreement was, going forward. And the implied license will be quite difficult to get away with. So I think I appreciate everybody's busy, and the top priority is perhaps not legally, like who owns the intellectual property. I'm not sure. So you often find that that's not something that's in the email correspondence. It's not entirely clear. You may be basing it on, I don't know, I guess if they've ever worked before, what the situation had been, also as evidence. But yeah, that's the sort of thing that you would have to fall back on in the absence of any agreement.
So let's put ourselves in the shoes of an employee. So let's say we have a designer who is employed by a creative agency, and that designer is tasked to design a logo for one of the agency's clients. So in that case, who owns the creative work?
I guess the first stage would be the employer owns the creative work, because if you are a graphic designer, and you're essentially designing graphics for someone, that is what you're employed to do, and therefore provided you are actually an employee, you've got an employment contract, it's pretty difficult to argue otherwise, and so the content would automatically go to the employer. It depends on what the employer's agreement is with the ultimate client, but you would think that in that scenario what they would have is a decent set of terms and conditions that say once you pay us, the rights and the content are assigned over to you, and that's probably how that situation would work. You obviously get into difficulty when there's no agreement between the client and the creative agency, but ultimately in that scenario it would be difficult to prove that it wasn't the employer as opposed to the employee that owned it. I think when you can get into difficulty is when, like I said earlier, if they're working at the weekend when they're not necessarily contracted to work and they're doing something that is quite different to what they'd be doing in their normal day-to-day job. But I do think as an employee that is always going to be quite a difficult argument to make. A lot of employment contracts say that you work 9 to 5 Monday to Friday and any other hours. No, mine does. So it's difficult to then say that because it was at the weekend it was not part of your employment, it's going to be difficult to make that argument. You do get some industries where that might not be the case, but that would need to be pretty explicitly set out in the employment contract. So yeah, generally I would say if you're an employee, your employer pretty much has the right to anything intellectual property wise that you create in your job.
So now this is a scenario about a client, so someone who's going to be commissioning a piece of creative work. Let's say it's a music label, limited company, and they hire a production company, also a limited company, and let's dub this production company A. And production company A is to produce a finished music video for a musician who's contracted to that music label. Production company A then hires production company B to film, edit, and deliver that music video. So production company B delivers that finished music video, and no written contracts were put in place. There's just, once again, emails, phone calls, there's an invoice, and it's all delivered, everyone's paid, everything's fine. However, the problem is no one really knows, so who owns the creative work?
So in that scenario, it sounds to me as though it would be the subcontractor that owns the rights to everything. I mean, I guess the party that has been engaged by the music label are just managing and overseeing the process. It doesn't sound like they are involved in any of the actual recording. Maybe they're just reviewing what their subcontractor does. Unfortunately, that doesn't mean that they have any right to the intellectual property, so it would be subcontractor that owns the rights to everything in that scenario. So, in that scenario, it's going up 2 different levels, and so I think, even more difficult to argue that there was the implied license, because that third, that subcontractor isn't even contracting with the top company. They're going through the middleman. So in that scenario, I'm pretty certain it would be the subcontractor.
So obviously, probably some mistakes have occurred there. If there is an assumption that there was going to be ownership of that material from production company A or the client, the music producer. So what if they send a contract after the fact, realizing the mistake? Do they have any legal standing to expect you to then sign that?
So if the work's already been done, and you've already been paid, then you don't need to sign it. If you envisage that was what should have happened but didn't, then it's maybe bad practice to just not sign it if that's what you'd always intended to do. But they certainly can't force you to sign something retrospectively. That's kind of their fault for not putting something in writing at the time that the agreement was entered into. We find this situation arises quite a lot where people enter into commercial agreements verbally. It's all in good faith, everybody's doing it on trust, and then parties stop using one another, fallout, difference in opinion, differences in personality, people decide to go elsewhere. You find further down the line you're wanting to, sell a piece of work that you've got, or sell your company, or get investment in your company, and you can't, because as it transpires, you don't actually have the right to use the work that you're using. So that's when you have to kind of go crawling back and say, look, we didn't get this done at the time. I think that was what the parties' intentions were. Would you mind signing this intellectual property assignation, which makes sure that what that does is that essentially is a sweeper that anything that you did in relation to that particular project resides with, is assigned over by you to the party that it was intended to go to. Presumably at that point you've been paid. Obviously if you've not been paid, you'd be like, no, I'm not signing it because you didn't pay me. But we have seen instances in the past where people are getting held to ransom, or somebody's having to actually go and find the person that actually created the work in the first place, because it was 10 years ago and nobody knows where they are now, and they're living, we did have one where the guy was living in Colombia and nobody knew where he was, and somebody had to find him and, get him to sign the intellectual property across to get the deal done. So yeah, you can't force somebody to do it, which is why I would always say just get a couple of pages, just setting out, look, this is what the relationship is. We're going to pay you this much. As soon as we pay you, the intellectual property and anything that you create in relation to this project is transferred to us. And then, you both sign it, and then hopefully that is sufficient. It doesn't need to be a big contract. It's just something to make sure that everybody's clear on what the position should be on the intellectual property.
So in a scenario like that, is a physical signature okay, or would an email do? What are your thoughts?
You need to sign it, so a reply in an email is not sufficient.
What if it was, what you dub a verbal agreement? Because it was pointed out to us recently that under Scots law, verbal agreements can be held up in court.
In Scots law, verbal contract is recognised. Problem with it is, how can you ever prove that it actually happened? So you would need to have had someone else there to have witnessed it. It's just one party against the other. And the same way that emails, yes, whilst getting an email from somebody, it's quite clear that they are saying you have the ownership to it. In reality, legally, that is not enough. And if you were an investor or if you were a buyer, you just wouldn't accept it. You would just say, there's absolutely no way that we are going forward with this until it's actually in writing, it's signed by that party, it's witnessed, or now we are using DocuSign, and obviously with DocuSign there are things built into the software that has capabilities to allow you to be pretty sure that the person signing it is the person signing it. Obviously, I guess with an email, that could be manipulated a lot more than having a signature, and so a lot of the time we are still saying, no, actually we want a wet ink signature, because we need to know, and we need somebody to have witnessed the signature so that we are comfortable and 100% confident that that person has signed. We've got their signature from the right person.
So, Louise, what can you do when a client ghosts your invoice, essentially doesn't pay it or cuts all communication after you've delivered a project? And how can we avoid this?
Sometimes we do it for customers of ours where somebody's not paid them and they want a scary letter from a lawyer. You can do that in the first instance. That sometimes works without having to go down the whole debt collection agency route. I don't know what they charge, but I guess there is a process that they need to go through. But yeah, getting payment up front is the ultimate way to avoid that. But yeah, depending on what the amount is, it could be that you take them to small claims court and sue them for the money, but nobody really wants to have to do that. So, I say to a lot of businesses, if you can take the money up front, then great. Or alternatively, if you can control taking back what you've provided them with, then, that is another way that you could maybe try and do it, but I appreciate that that's not possible in all scenarios. So
yeah, getting paid as a creative and payments for creative work can often be a challenge. So, one way to approach it would be classic 50% upfront to lock in that job, and then 50% once everyone's happy. Everyone has signed off the project itself. Once that 50% is paid, then the project's delivered, and that's something that we've seen tried and tested across the creative industries.
Yeah, that seems fair, because at that point at least you know that they are happy with what you've provided, and so there can't really be much debate as to whether or not you're due what you're owed.
So Louise, it's pretty complicated scenarios and I guess the subject matter in general. So what would be your key pieces of advice for our viewers to take forward into their working practice?
I think, typical lawyer comment, always everything in writing, but in reality, it depends on where you sit in the chain. So if you are a freelancer, then, perhaps what you need to be doing is saying to your commissioner, do you have terms and conditions? If so, what are they? Can I see them? Because a lot of the larger organisations that you're contracting with will have something in place, and if they do business properly, they should really be sending that to you at the point that they're asking you to do something. If they don't, then ask to see it, and if they don't have anything, then it might be worth you having to think about whether or not you have your own consultancy agreement as the freelancer or consultancy agreement as the ultimate commissioner to say, look, this is what I'm asking you to do. There's a schedule setting out what your role will be. This is what I'm paying you. This is, what my expectations are around intellectual property. This is what you'll be creating. And if you're using anybody else's content, then I want something from you to say that you've got the right to use that content. And it can be pretty short. You could do a short form kind of consultancy letter. I think just having something to give you comfort that you have what you need and not to just rely on trust, because, you know, as a lawyer, don't trust anybody. You always get everything in writing. So even if you don't have something in writing, just, you know, try and be clear with the other party as to what your expectations are. And even if that is just a written bit of paper that says the IP and this is assigned to X, you both sign it, that's better than nothing, and certainly would get you some way in terms of proving where the intellectual property sits. If you're contracting with somebody who's quite big, like I say, they might have their own and they don't want to be signing yours. But if nobody else has anything in place, then at least you can present them with something and say, look, this is what my expectations are. If you want to negotiate on the terms of it, then fine. But at least maybe just having a little style one put together that you can roll out, it certainly helps, and it focuses everybody's minds so that they understand what it is that they're all agreeing to.
Louise, we've taken up far too much of your time already. Thank you so much. Really appreciate your time. I hope our audience has also enjoyed hearing from your insight. Absolute pleasure.
Yeah, thanks, Louise. That was super insightful, and I'm sure everyone at home will have taken some piece of valuable information away with them. My main take home from all that, and like you said, it's very cliche, but get it in writing. If you don't have it in writing, you've got no safeguard, you've got no backup. You can't really protect your work.
Yeah, absolutely. I would say the more you understand this subject matter of intellectual property, copyright, and are able to actually talk about this with your employer, your client, your freelancer, whoever it is you're working with, super valuable. And I guess last thing, Louise, is there anything that you would like to say to our audience before we ask them politely to follow From the Field and hit us up on your socials and ours?
If there are any things that come up that anybody wants to talk about, then yeah, please get in touch. Be happy to help at Harper McLeod. We work with quite a lot of different forms of media companies, and so yeah, we've got the experience there if you need it.
Absolutely. I would encourage people to go and check out Harper McLeod if you're looking for some help, advice and support with your legal challenges, especially in the creative industries. And all those socials are here. You know what to do. You can head over to FoSho STUDIOS. You can sign up for our newsletter so you'll be the first to know about our next From the Field. All the socials, of course, you know, follow, like, subscribe, share it with someone that you think would find this valuable. Martin, anything more to add?
Absolutely not. Let's cut it there.